My name is Jesper Lohse. I'm the chairman of the Danish Father Association, also coordinating chairman of the Nordic Fathers, member of the National Human Rights Council, and advisory court member of the National Family Courthouses in Denmark. But what is most interesting is probably that I've made our case analysis of the Danish family system from a leadership perspective. What I'll talk about today is the Supreme Court decision that's going to be made on a shared parenting case, the largest one we've seen in Denmark. It is a human rights case against Denmark on shared parenting and gender equality for children and fathers. What started up the case is that we've been working for 10 years trying to establish shared parenting law reforms. We have been sending out press releases every week to all parliament members, to all courts in Denmark, to all the public authorities and the ministries related to the children law and shared parenting. We received a letter from the minister at the time in which the minister stated that I must therefore maintain that I do not agree that the family law legislation or the system in general treats the children or one of the parents differently than the other. On that basis, since you are meeting with the Minister of Gender Equality, I do not think there is a need for a meeting. This was the first time that we experienced that we could not get a meeting with the minister in the social ministry responsible for children and parent legislation in Denmark. We also had confirmation and documentation that the minister did not think that there was a violation of the UN Convention on the Rights of the Child and the European Convention on Human Rights to ensure the rights of the child, including that the child has the right to contact with both parents. So based on this minister letter, we established a legal team and we took the Danish government to court on August 8, 2023. The case was made by the Danish Father Association and me as legal person, as the chairman of the association, filing the case against the Prime Minister's office and the Ministry of Social Affairs, Housing and the Elderly, which is responsible for children legislation in Denmark. The claim was that the defendant, Social Housing and the Ministry of the Elderly, must, as the responsible ministry, together with the Prime Minister's office, recognize that there is discrimination against children and parents as a starting point in relation to family forms, place of residence and contact parents, as well as gender, both directly and indirectly. All citizens are not equal before the law, and individuals are concrete decisions are not made in the family law system, which is a breach of the UN Convention on the Rights of the Child and the European Convention on the Human Rights, the Equality Act, and also the Ministerial Accountability Act. Therefore, we ask that the defendant ensure that the legislation and practice in family law and the family law system applied equal to all children and parents as a starting point. So we took the Danish government to court in 2023 and related to shared parenting. And what we have done in the legal case is that we have gone through all parts of the law. We have found 12 different themes and 366 items in the law where we have found that people are not parents and children are not treated equal by law. We have shortlisted out of the 366 items, we have shortlisted 24 items, which is the claim in the case. The primary claim is that we want the defendant, the Prime Minister office and the Social Minister to acknowledge that the Parental Responsibility Act and the division between a residential and non-residential parent is both direct and indirect discrimination. It's direct discrimination of parents and it's indirect discrimination of fathers, because we can document that the same level of children in relation to women, between men and women, the same level of children today has living address at the fathers as in 1980. And in our society, in the Nordic society, gender equality is a norm, shared parenting is a norm in society, and therefore we see more fathers being responsible for children, taking care of children. 50-50 is the most used visitation form, and also the fastest growing. So when there's not happened anything on this number between the ratio between residential parents from 1980 and until today, we are able to document that there's clear discrimination by law. This is not the free will of the parents, it is a legal issue. As a second claim, we also find that the family court practice and the family court houses in Denmark in disputes of residence and contact are in contrary to the Equality Act, and therefore their decisions are invalid or legally ineffective. So every decision that has been made by this case should actually be proven to be invalid or legally ineffective. We are taking up claims 3 to 9 in the court case where discrimination of residence and visitation parents is indirect discrimination of fathers, and we go into specific parts of that claims. In claim 10 to 11, we target the discrimination that is in the case of violence against fathers in family life. And what is interesting is that we have already, after starting the case, seen the first changes in the Danish law. Today, if a parent goes to a crisis center, that for decades that has only been crisis centers for women, but today by law in Denmark, crisis center are gender equal, and that means that they both have to apply, the same condition applies for both men and women experiencing family violence in family life. Claim 22 to 33 is discrimination of welfare benefit, which is one of the big issues, of course, in the Danish society, where we are using a lot of these welfare benefits for parents. But welfare benefits for children is based on the resident parents. It's not based on the abilities for both parents to have welfare benefits if they have need for it, or for the non-residential parent to have the welfare benefit. Claim 24 to 25 is about discrimination on treatment of paternity leave, where we see that paternity leave legislation has been decided by the European Commission, European Community, in all countries in Europe. The fathers has at least 2 months of paternity leave, which is paid by the government. That is applied by law today. The Danish government has tried to come out of that, but the European Commission would not allow that. So it's also part of the Danish legislation today. And actually, they have then decided that parental leave is divided 50-50 between the parents as the basic assumption. 3 months is earmarked for both parents, and the rest is just can be decided by the parents between them. But what the Danish government has done is that they only applied this legislation in traditional family form and not to home families, or if the parents has never been living together. And this means that if the woman wants to have, the mother wants to have the paternity leave, and we see that mainly that's important in cases where the mother has issues in her background, where the child actually has a need for the father to be there, to be an equal parent. Well, that is the cases where you then can get a divorce, and then the woman will get most of the paternity leave. So we are stating that this is discrimination of family forms, not necessarily gender, but also indirect gender. But it is a discrimination of family forms that has different legislation, whether the father and mother live together or not live together. But this is, as I stated, this is the 25 claims that we have shortlisted from our list of 366 items, and these are the claims that has been taken to court against the Danish Prime Minister office and the Social Ministry, which is responsible for children law in Denmark and also the coordination of the children law. Looking at the timeline for the case, we took the government to court on 8th of August 2023. We are working with a team of lawyers, of course, in Denmark, human rights lawyers that are assisting us in running the case for the Danish Father Association and me as a person, as a legal person. And we submitted in 22nd of December 2023 the full summons with documentation where we documented the different parts of the law in which there was no equality. And we also filed a number of surveys with between 1,000 and 500 parents, 5,000 parents, where we could document that people, citizens, are not treated equal. We provided a witness list which includes some of the leading researchers around the world, but also ministers and public directors that will go to court and discuss these matters on shared parenting. On 18th, so the decision was made by the High Court in Denmark on 4th of May 2024 that this case has principal character related to society, and therefore it was immediately transferred to the Higher Court. The Attorney General's appealed that decision by the High Court, and the decision, the complaint was rejected on the 4th of October 2024. Then in November, 11th of 11 in November this year, the High Court decided that they want to hear the Supreme Court on this. They referred the case back to the District Court, to the High Court, and that means that it has to be up to the Supreme Court now to make a first decision on this court case, whether the Supreme Court find that the case is principle for society and should be handled later on by the Supreme Court expected, but has to start in the High Court. So right now we are waiting for the Supreme Court decision, their first decision on this case on shared parenting legislation. And if the Supreme Court finds the case principle for society and related to human rights treaties. If the Supreme Court finds that it is principle for society, then the High Court will have to start the case. And if they do not think that in the first instance, then the case will start in January 2026 at the District Court. So this is the case which is the largest of its kind we have seen yet on shared parenting and gender equality, but also the largest case for children and fathers to date. We are using one legal person, one legal father, and we are not doing it with 100 or 1,000 or 10,000 of fathers, because we know that there has been Supreme Court cases before that, and the court has found that they have to handle each of the father cases individually, and therefore they are denied those cases. So what we are doing this time is that we are trying to take a shortlist, 25 specific items that is very clearly can document is a violation of human rights and discrimination on family forms and also gender. And we have shortlisted the 25 items out of the 366 items found, and we are taking them to court with one Nordic Father running the case. What we also recommend in the court case and to the Prime Minister's office is a new and modern family law. We have no doubt that the future family law can be based on 3 basic principles, and we have to make a law like that. Step 1, everyone is equal before the law in relation to gender and family forms, with a focus on the child's right to both parents as the starting point. Step 2, the parents are free to make their own arrangement based on that. And step 3, a family court, of course, should decide on factual concerns for children and also reward good parenting behavior and competences by the parents instead of gender. That will, without a doubt, be the future in family law. We have made 10 recommendations on which you can make a modern family law. This is what is needed. You don't need tens of thousands of documents with family law. These are the basic principles that you need to have in your family law to make it succeed in today's society. So the 10 different recommendations is item 1. The child's parents are the biological father and mother with respect for other caregivers who give the child love, care, and security in life. Children have a human right to know and be cared for by their parents. Item 2, the child's parents must receive public and private information at the same time and in the same method. Item 3, the child has the right to equal parenting leave with its parents. Item 4, all parents have joint legal custody by law. Only weighty circumstances count against that. The court can make decisions about DNA testing throughout the lives of the child. It's only by the truth that we can protect children today. And of course, a child has the right and the parent has the right, if it's decided by a court, there's reasonable ground for that, to make a DNA testing to make sure that there is a child-parent relationship. Item 5, if the parents do not live together, the child has shared residence and equal time as a starting point with its parents. Item 6, the child's income and expenses are divided 50-50 between the parents at equal or larger equal time, and in that we refer to 50-50 or 65-35 arrangements. If there's weekend arrangement, one parent ensures the child's finances against a normal child allowance. Item 7, if a parent moves away from more than 80 kilometers 1 hour, the moving parent take care of transportation, the child as a starting point. Item 8, the parent can make other arrangement on these decisions if desired. And item 9, if there is a material concern for the child by a parent or the authority, the matter is dealt with by a family court, of course, with children experts, and a certified guidance for the child may be involved. And item 10, a child expert in family law can, for compelling reasons of family courts, make a different decision with a focus on equality, documentation, and the best interest of the child and the family as a whole. But all legislation, all allegation of criminal offenses has to be dealt with by the police. Using these 3 principles and 10 recommendations, we want to secure future family law in which everyone must be equal before the law to create a success. That applies in other parts of the society, and of course it should also apply in family law. This does not mean that we will see more fathers than mothers having children and taking care of children. We will see many years and maybe everywhere where in the future still having women and mothers looking more after the children as fathers, and maybe we will see more fathers having job careers than mothers being in boards. But the family life is changing dramatically, and what is important is that we have the equal and the same opportunity for both parents, and what the parents are going to use that equality to, that is up to them. We will see a lot of different family forms, and we already see that in society today. And what we need to do is to apply the law, the future family law, for the modern family society. If you want to have more knowledge on this, we have made a briefless small book called Fathers, in which you can see all the 366 items and the basic principle for shared parenting law. You're also welcome to connect with me on Facebook. I have a Jesper Lohse official Facebook page. There's a LinkedIn page, and you can go into Amazon and also get these books or brieflets. What we are doing is, of course, that we are looking into the Council of Europe Resolution 2079 that was made in 2015. We were part of doing this. That is a resolution that should support gender equality and the role of fathers. And it had 10 items, which they stated that this was important for society. Denmark is without a doubt one of the countries around Europe and probably the world that is further ahead, together with states in the US that has even progressed more on equal parenting and having 50-50 as the basic assumption by law. But Denmark is definitely one of the countries that are further ahead on the Council of Europe resolution, and that's of course very positive. But still, we need to mainly secure that we don't work with a residential, non-residential parent, that welfare benefits is something you get if you need it, and not based on your gender, not based on your residential position. So the different parts of the Council of Europe are in line with our recommendations and will actually secure the Council of Europe Resolution 2079 that was anonymously voted through by the Council of Europe and is also progressing into the European community. This is the resolution that secured introduced paid parental leave available to all fathers for 2 months around Europe. We also have a Nordic Fathers survey, which is one of the largest surveys we have seen of fathers. 3,500 fathers joined in from the Nordic countries towards the UN Global Goals, where we ask them, well, what is your current view on gender equality in the family life? And we have made surveys with all of these fathers, and this is the report that can also be downloaded from Amazon with representatives from each of the Nordic countries, and you can go in to look at demographics, the gender equality aspects, the impact and effects of the family law. We are doing data analysis on the report and Nordic comparisons, and you can also go into each of the countries and see the different country reports. So you are, of course, welcome also to get that on Amazon. The last thing I want to mention is one of our new projects, which is a new international project. It started up national in Denmark, but it's going into the national international project now. We call it Take It, and we call it Take It as a Man or Take It as a Woman. And it's an 8-week course for 8 parents, where 8 parents get together. They meet each other and they listen to their own experiences in family life and in the family court system. They have some great talks. There's coaches and a therapist involved in the courses, so they make sure to facilitate the courses. And for parents that has experienced severe divorces, long processing times, gender equality, parental alienation, lost contact with children or have experienced family violence. This is one of the projects that we can see that actually works, where we put 8 parents together. They have the chance to talk about the situation and their experiences for 8 weeks. They meet 3 hours every week, facilitated by coaches and therapists, and talk about sadness and sorrows and positive way forwards and help each other. So you can definitely look into that project. It's called Take It on the website, worldparents.org. We're also running it in Denmark, and the Gender Equality Ministry has just in Denmark funded the project for 3 years. So in 2025 to 27, we will be running this project nationally in Denmark, but we also further enhance it into the Nordic countries or as an international project if that is needed. Thank you. That was all for me for today. Enjoy your evening.